Prior to coming to the bench, I did have the opportunity to review the entire case file. I reviewed the pre-sentence investigation report. In that pre-sentence investigation report, it does list your prior criminal history. You were adjudicated delinquent on December 13th, 2019, placed on 6 months of community control in case 1911156, disorderly conduct and riot. On that same date, in case 191116465, also placed on community control. That was the breaking and entering and vandalism and possession of criminal tools initial charges. Also, in case 191112291, on the same date, you're adjudicated delinquent, placed on 6 months of community control. This being for the disorderly conduct, criminal trespass, riot, failure to disperse. As an adult, in case number CR 22-668-827, you pled guilty to burglary, a felony of the 4th degree, and assault, a misdemeanor of the 1st degree. You were given community control sanctions by this court. You violated your community control on 12/15 of 2022. A capias was issued on April 4th of 2023. You were in custody on May 31st of 2023. And then comes these two cases, case 684127, where you pled guilty to breaking and entering, attempted grand theft, both felonies of the 5th degree, and criminal damaging misdemeanor of the 2nd degree, as well as CR 23-681-665, where here you're in front of the court on the aggravated vehicular homicide charges that you pled guilty to. There was no statement given by you at the time of the probation violation. You have almost all medium risk scores, as well as a high for education, employment, and finance. Courts reviewed the attached victim impact statements. I've heard from the victims' families and from the assistant prosecuting attorney. I have reviewed 2929.12 for the principles and purposes of sentencing. I have also reviewed 2929.12 for the seriousness and recidivism factors. And 2929.13 and other revised code sections for felony sentencing. And 2929.21 for misdemeanor sentencing. The court has formulated the following decision based upon the overriding principles and purposes of felony sentencing in 2929.11, which are to protect the public from future crime by the defendant or others and to punish the offender using the minimum sanctions that the court determines accomplishes those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and providing for restitution. And I have considered all of the relevant sentencing guidelines provided in, again, revised codes 2929.12, 2929.11, 2929.13, as well as 2929.19, and all sentencing guidelines and statutes. In case number CR 23-684-127, this is for breaking and entering, felony of the 5th degree. You will receive a 1-year sentence for the Count number 2, attempted grand theft, felony of the 5th degree, you will receive a 1-year sentence. For criminal damaging, count number 3, this is the misdemeanor of the 2nd degree, you'll receive 90 days. That 90 days must be run concurrent by law to the underlying breaking, entering, and attempted grand theft. In case CR 23-681-665, for the aggravated vehicular homicide, you'll receive a sentence of 7 years on count number 3. For the aggravated vehicular homicide, count number 4, you will also receive a 7-year sentence. Court finds you to be a probation violator. In case 668827. For that burglary felony of the 4th degree, you will receive a 1-year sentence. For the assault misdemeanor of the 1st degree, a 90-day sentence. By law, that misdemeanor must be run concurrent to the burglary charge. Case number 684127. For that 1-year sentence, that will be run concurrently. Case number 681665 and 684127 will be run consecutively to each other. The 2 counts will also be run consecutive to each other. The total sentence here is a 15 to 18.5 year sentence. Court finds count number 3 to be the qualifying felony of the 2nd degree. 50% or 1/2 of 7 is 3.5 years. So 7 plus 7 is 14 plus the 1 year consecutive in case 684127 makes it 15 to 18.5. You're to serve a minimum prison term of 15 years with an indefinite prison term of 18.5 years. 3.5 years for a maximum prison term of 18.5 years. Total stated prison term being 15 to 18.5 again. As to the consecutive findings under 2929.14 C4A, they impose these terms consecutively to each other. That is the 2 felonies of the 2nd degree, as well as case number 684127. Finding that the consecutive sentences are necessary to protect the public from future crime or to punish the defendant, that the consecutive sentences are not disproportionate to the seriousness of the defendant's conduct and to the danger the defendant poses to the public, and that the defendant committed 1 or more of the multiple offenses while the defendant was awaiting trial or sentencing or was under a community control or was under post-release control for a prior offense. Again, the defendant having been on community control at the time that he did this with a violation in the caveus 684127. The court also finds under 2929.14 C4B consecutive sentences to be appropriate as the court imposes these terms consecutively, finding that the consecutive service is necessary to protect the public from future crime or to punish the defendant, that the consecutive sentences are not disproportionate to the seriousness of the defendant's conduct and to the danger the defendant poses to the public, and that at least 2 of the multiple offenses were committed in this case as part of 1 or more courses of conduct, that the harm caused by said multiple offenses was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of the defendant's conduct. The defendant, having committed a theft offense, stealing this car as well as stealing a car at 684127. I agree with the assessments by the state, by the victims, families who have spoken to the court here. You were under a habit of stealing cars, clearly driving them recklessly and at very excessive speeds. The court imposes prison terms consecutively under 2929.14C4C as well, finding that the consecutive service is necessary to protect the public from future crime or to punish the defendant, that the consecutive sentences are not disproportionate to the seriousness of the defendant's conduct and to the danger defendant poses to the public, and that the defendant's history of criminal conduct demonstrates that the consecutive sentences are necessary to protect the public from future crime by the defendant. This is not business as usual. The amount of grief here is astronomical by all parties, by your family, sir, as well as the two families on the other side of the room. I can't imagine having to deal with these losses daily and your reckless disregard for others. You say this person was like a brother to you, like a friend. It's hard to say, and I certainly don't think that either of these two losses were worse than the other. All three families here are devastated. I'm also taking into account the mitigation that you've provided in not sentencing consecutively on all counts, on all three cases. And running one of those cases concurrently. I find you do have a level of some remorse here, sir. I'm not sure you don't understand everything here that occurred. And you are 19 years of age. Or were at the time. There is a Class 2 suspension of your license for life, sir. I don't believe that that's just a technical issue. You were driving under suspension, and you showed no regard for the law in attempting to have a license or be regulated in any way. As we discussed, your aggravated vehicular homicide counts are mandatory sentences. Once you are released from your service in prison, there is a post-release control period. Mr. Brinkman, for these offenses here, felonies of the second degree, this is a mandatory term of 3 years, is that correct? Or because of a homicide, did we not, we discussed this before, that these are 5 years?
Yes, Your Honor.
One more. These are Mr. Brayman, could you look that up carefully again?
Yes.
For the court? On your felony of the fourth degree burglary charge, adult parole authority may supervise you for a period of 2 years at the discretion of the parole board. same goes for your breaking and entering charge, felony of the 5th degree, and attempted grand theft, felony of the 5th degree. These other charges, aggravated vehicular homicide, are felonies of the 2nd degree. Mr. Bringman?
Your Honor, it's 18 months to 3 years for the second felony.
Yes. Mandatory minimum of 18 months up to a maximum of 3 years. All right, thank you. The court has looked up the statute as well on that. If you violate any post-release control rule or condition, you may be subjected to a more restrictive rule or condition, a longer duration under supervision, or you could be sent back to prison even though you have done all the time to which you had been sentenced. You could get up to 9 months in prison for each rule violation. The total, however, for all rule violations cannot be any more than 1/2 of the prison sentence that you receive unless the rule violation is for the commission of a new felony, in which case you could receive a prison term of the greater of 1 year or the time remaining on post-release control, in addition to any time that you receive for the new felony. The post-release control prison term must be served consecutively to any prison term that you receive for the new felony. Mr. Schlackett, you believe that there's 181 days of credit for time served. Is that correct?
Yes,
sir?
Your Honor. The document reflects that he was arrested on May 30th.
Okay. Do you have a motion as to indigency, sir?
He's indigent for any purposes, Your Honor, with respect to fines and costs.
Court costs and fines will be waived due to the defendant's indigency. You will receive credit for time served for 181 days. Anything further from the state?
Thank you.
Mr. Schlackett, anything
No,
further?
thank you, Your Honor.
All right. The sheriff to deliver him.